So many body cams of situations that go completely sideways and people get hurt start off by people saying that they have the right to sit in their car.
Out of the car.
You do not have the right to do that.
I do have the right. I'm giving you a lawful order.
A police officer tells you to get out of that car. You are getting out of that car.
I don't need probable cause.
Period.
Welcome to the Cuffs and Case Law podcast, where we read case law so you don't have to.
Yep. I'm Nate. That's Dave. We're cops. We're not lawyers. So you ready to get into this, dude?
Just to set up the show, as
Yeah,
we
you should
fail to
probably do
sometimes do that.
Most of the time.
Nate does all the research for these cases, and he
Mhm.
tells me absolutely nothing. So
Nothing.
what you're seeing is my genuine reaction.
I surely hope you're at least vaguely familiar with both of these cases.
I, at
Please.
least in the intro, was confident that I had a clue as to what these cases are,
That is a good start, David.
which is completely different from episode 1.
Yeah, so both of these cases involve police officers who ordered occupants to exit vehicles during traffic stops. And believe it or not, evidence was discovered in that, and court battles ensued because that's precisely how we make case law. Both of these cases hinge on what is a super common constitutional analysis that we talk about all the time, and we're going to talk about it again. And that is the analysis of government intrusion v. personal security and liberty, right? So
And that's a balancing act.
it is a balancing act. The touchstone, you might call it, of the Fourth Amendment analysis is the reasonableness of the particular governmental intrusion on a citizen's personal security. And that reasonableness depends on a balance between the public interest and the individual's right to personal security free from arbitrary interference by police officers.
Which is kind of interesting when you're talking about this, because I obviously know it's about officer safety. And
Yes.
from the comments on Terry from episode 4, people don't seem to think that matters.
No. And
so
we're-
here we go again.
I'm glad you actually brought that up, because the Supreme Court of the United States in both of these cases says a lot of things about traffic stops and the inherent dangers therein. And as I'm reading those and thinking about Terry and a lot of normal people's views, I don't know that your average citizen on the street would necessarily agree with the Supreme Court. So in an effort to defend that, I actually have some numbers that we're going to go into.
I'm glad I could just lead right into that.
You did. Yeah, you
I'm a great co-host.
You are the best co-host.
A blind co-host that somehow always finds the nut.
Yeah,
Call it.
we'll call it that. All right, dude, you ready to get in the nuts and
Let's
bolts
go.
of this? All right. First case. Yes, you were late on that.
I was late.
You were late.
I'll cut it so it looks
Remember
more
when you said you
correct.
were the best co-host?
I quickly
Nope.
failed.
You've lost it. All right, first case is Pennsylvania v. Mimms, and it comes to us from 1977.
Here we go back in time.
Yeah, we do. In
All
this
the
case,
pivotal cases, though.
yeah, all the big ones. Well, not all the big ones. Most of the big
No.
ones. But this case involves the traffic stop and subsequent arrest of Harry Mimms.
Harry Mimms.
Harry Mimms. Supreme Court starts by saying the facts of this case are not in dispute. So we're not arguing the particular facts of this case at all. And then they lay them out. So while on routine patrol to Philadelphia, police officers observed Harry Mimms driving an automobile with an expired license plate. Believe
Can't
it or
do that.
not.
Expired.
So the officers stopped the vehicle.
Expired. Expired. You're welcome.
Thank you. All right. So the officer stopped the vehicle for the purpose of issuing a traffic summons, a ticket, a citation,
Yep.
whatever you call it, right? One of the officers approached and asked old Harry Mimms to step out of the car and produce his owner's card and his operator's license.
Owner's card.
I think it's like his registration. I would
Okay.
presume that's what it means. So he says,
I haven't
hey,
heard it ever called that.
hey, Harry, get out of the car and bring your owner's card and your operator's license with you. This is great. I did this just for you. The court says that Mimms alighted.
Alighted. Not
Mhm.
obliged him.
No,
Alighted.
alighted. So in preparation for this case, I pulled a definition for you.
I knew you would, because I was going to ask you what that means.
I knew it. So I pulled it. Alighted is the past tense of alight, which is super helpful.
That doesn't help at all.
Meaning to descend from a vehicle, as in disembarking, or to land gracefully from the air, as in to perch.
Not
it-
enlighten me.
Alighten.
Alight.
Yeah, with an A. It originates from Old English
Of course it does, because you love Old English.
I don't, but it's just common and is often used in literature to describe birds settling or passengers exiting and has a formal and poetic tone.
And why the Supreme Court chooses to use Old English
I don't know, man.
baffles me.
Yeah.
Other than that, they
It's formal and poetic. Maybe that's why,
yeah,
because it's such
they
a
want to sound smarter,
yes, and fancy.
or they just want to make sure that we don't understand
Well,
anything they write.
They can't just say old Harry got out of the car.
Why would we do that?
It's much better to say that Mimms alighted.
Ugh.
Whereupon the officer noticed a large bulge
Mm.
under the respondent's sports jacket.
Well, that could have been Harry being excited.
They could have just said Harry got out of the car and the cop saw that he was printing, but
No.
that's not what they said. Mimms lighted, whereupon the officer noticed a large bulge under
Yeah.
the respondent's sports jacket.
Because he likes traffic stops.
Fearing that the bulge might be a weapon, the officer frisked Mimms and discovered in his waistband a .38 caliber revolver. Another common
This is
theme.
very Terry
Yep,
so far.
loaded with 5 rounds of ammunition. It's always a Stump-Nose 38
Yeah.
Saturday night special. Always. I mean, it is 77, I guess. But the other occupant of the car was carrying a .32 caliber revolver on him.
Were they going to rob a jewelry store?
Doesn't say. And if
course
it did,
not.
I wouldn't have the name of that jewelry store for you.
No, you certainly would not, because context only matters to me.
It's not true or fair. All right. So old Harry Mimms was immediately arrested, and he was subsequently indicted for carrying a concealed deadly weapon and for unlawfully carrying a firearm without a license. So it goes up to the trial court, and believe it or not, old Harry Mimms, he
Please,
filed
no contest.
no. He filed a motion to suppress
No, yeah.
the
That's always
revolver.
comes first, and then it's
Yeah, saying that it was seized after he was unlawfully ordered to exit the vehicle. Well, the trial court denied that. And so the revolver was introduced into evidence, and he was convicted on both counts. So he was displeased with this fact. So he and his lawyer appealed up to the Supreme Court of the state of Pennsylvania. And the Supreme Court of the state of Pennsylvania reversed Mimms' conviction.
early reversal.
He held
Very California of them.
Yeah, it is. They held that the revolver should have been suppressed because it was seized contrary to the guarantees contained in the 4th and 14th Amendments of the United States Constitution. What's the 4th Amendment say?
You're going to do this again?
You better believe I am.
The right of the people
Mm-hmm.
to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. And no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the places to be searched and the persons or things to be seized.
Gosh dang it.
I nailed that.
You crushed it.
Great success.
Absolutely crushed it. What's the 14th Amendment say?
It's made applicable to the or the 4th Amendment's made applicable to the states by the 14th Amendment.
Gosh,
That's all I got.
I don't even know why we need to continue this podcast because you got
we
it.
still have a lot of cases to cover because they
we
use
do.
alighted.
Good job,
which I'm
dude.
going to use now because that's actually applicable to daily life.
It totally is. Good job. You crushed that. So
Thank you.
the Supreme Court of the state
Your
of
wife owes me
Pennsylvania.
2 dinners. Just let her know. She's got a tab.
Supreme Court of the state of Pennsylvania
But
says
she can't pay up because we haven't gotten to 1,000 views on one of these long form videos. So please help us out and
that
get
is
me
true.
fed on his dime. And also a good reminder that we're looking for 500 subscribers and Nate's going to take his shirt off.
I am
So
not taking my
yes,
shirt
you
off.
are.
David.
Your wife
No.
already said yes. 500 subscribers. We're almost there.
Yeah, get there. The Supreme Court of the state of Pennsylvania reversed Mimms' conviction, and they said that the revolver should have been suppressed because it was seized contrary to the 4th Amendment. The Pennsylvania court did not doubt that the officers acted reasonably in stopping the car. It was also willing to assume that the limited search for weapons was proper once the officer observed the bulge under old Mimms' coat.
Yeah.
But the court nonetheless thought the search was constitutionally infirm because the officer's order to Mimms to get out of the car was an impermissible seizure, is what they said. So they said, stop's good. If you just teleport him out of the car, you see the bulge in his jacket, your Terry frisk is good. But the only reason you saw that in the first place is because you unconstitutionally ordered him to get out of that car. So that was the position of the Supreme Court of the state of Pennsylvania. This was
probably be the still people's opinion of this.
exactly right.
The
So-
general public's opinion.
Yes. So they said that that was their opinion because the officer could not point to, quote, objective, observable facts to support a suspicion that criminal activity was afoot or that the occupants of the vehicle posed a threat to police safety. So they said because you didn't have reasonable articulable suspicion specifically that was the impetus for you asking him out of the car because you didn't have that. It's no good.
You just wanted documents.
Yeah. Since this unconstitutional intrusion, says the court of Pennsylvania, led directly to the observance of the bulge and to the subsequent pat down, the revolver was a fruit of an unconstitutional search.
Fruit of the Well, I don't have anything.
Yeah, I thought you'd have
Fruit of the
something
unconscionable bulge, sort of.
kind of. And in view of the Supreme Court of Pennsylvania, it should have been suppressed. So they continue all the way at the flagpole to the Supreme Court of the United States, who grants
certiorari.
And the very first thing they say after outlining what the Supreme Court of the state of Pennsylvania says is, yeah, no, we don't agree with that conclusion at all.
You guys suck.
just right out of the gate.
Wow.
We do not agree with this
That's
conclusion.
literally what they start with.
That's what they start with. So they
Wild.
start with saying, all right, here's the facts. Here's
We don't dispute this.
how it's made its way through the courts thus far. And then the first words out of their mouth is, yeah, we don't agree with their conclusion.
Is this Earl time or
No,
past Earl?
this is not. We're past Earl.
Man.
Yep. All right. So the Supreme Court then obviously goes into justifying why they disagree with the Supreme Court of the state of Pennsylvania. And they say our analysis under the Fourth Amendment is always the reasonableness in all the circumstances of the particular government invasion of a citizen's personal security. They said that in quoting Terry. In this case, however, unlike Terry v. Ohio, there is no question about the propriety of the initial restrictions on old Mimms' freedom of movement because the stop's not argued. Stop's good to go. Mimms was driving an automobile with expired license tags in violation of the Pennsylvania Motor Vehicle Code. So
keep your tags in line.
Yep. Then they say, deferring for a moment the legality of the frisk once the bulge had been observed, we need presently deal only with the narrow question of whether the order to get out of the car,
a light,
yes, issued after the driver was lawfully detained, was reasonable and thus permissible under the Fourth Amendment. So they're saying same thing kind of what the previous court said is stop's good. We're going to set the frisk aside. We're literally only talking about whether or not the order to get out of the car after he was lawfully detained was reasonable. So this inquiry must therefore focus not on the intrusion resulting from the request to stop his vehicle or from the later pat down, but on the incremental intrusion resulting from the request to get out of the car once the vehicle was lawfully stopped. So they're saying you've already intruded on his liberty, right? So all we're looking at is that little incremental intrusion of now you're getting out of the car. And like they love to do, they present both sides of the argument. So they start with the governmental interest side.
Yep.
And they say, okay, placing this question that we're talking about here in this super narrow frame, we look first to the side of the balance, which bears the officer's interest in taking the action that he did. So what governmental interest do we have in asking people out of the car? The state of Pennsylvania freely concedes that the officer had no reason to suspect foul play from the particular driver at the time of the stop.
Didn't realize they were both packing.
No, yeah. At the time, he had no reason to suspect foul play from either one. There having been nothing unusual or suspicious about his behavior. That is super important. It was apparently this officer's practice to order all drivers out of their vehicle as a matter of course when they had been stopped for a traffic violation. So this guy, this is what I always do. No, I didn't particularly think anything suspicious about old Harry Mimms.
I just always do this.
There wasn't a particular reason. I just always do this. So the state argued that this practice was adopted by the officer as a precautionary measure to give him a degree of protection, right? And the
Although
state,
your tactics podcast might disagree with that.
the state said it may be justified on that ground, right? So establishing a face-to-face confrontation diminishes the possibility, which is otherwise substantial, that the driver can make unobserved movements. That's the first thing they point to, right? This, in turn, reduces the likelihood that the officer will be the victim of an assault, says the Supreme Court. So if you get him out of the car, he's not going to be able to reach under the driver's seat and get a gun, right? He's not going to be able to move around and make things advantageous to his situation for an attack without the officer clearly looking at him, right?
You're taking it from a home game to an away game.
Correct. Exactly. So the Supreme Court says, they again quote Terry, and they say, certainly it would be unreasonable to require that police officers take unnecessary risk in the performance of their duties. And, says the Supreme Court, we have specifically recognized the inordinate risk confronting an officer as he approaches a person seated in an automobile. They then go on to quote a study of Bristow and police officer shootings. A tactical evaluation is the name of it. And according to one study, approximately 30% of police shootings at the time occurred when a police officer approached a suspect seated in an automobile.
That's a lot of percent.
30% at the time. So they're like, yeah, we have specifically recognized that traffic stops are dangerous for cops. And here's a study that justifies the position that we've already taken, right? We are aware that not all of these assaults occur when issuing traffic summonses, but we have before expressly declined to accept the argument that traffic violations necessarily involve less danger to officers than other types of confrontations. That's quoting a state of United States versus Robinson, which I guarantee is going to be on cuffs and case law at some point. But in that, there's
How old is that one?
73. So that was 4 years before this, and they're like, I'm telling you that our position as the Supreme Court is that traffic stops are dangerous. We can back up this position. It's been our opinion for years. They're dangerous. And they go on to say, indeed, it appears, quote, that a significant percentage of murders of police officers occur when the officers are making traffic stops. And they don't stop there. They then go on to talk about how dangerous traffic is, right? They hammer home that,
and playing in traffic, not a good idea.
Yeah, not a great idea. The hazard of accidental injury from passing traffic to an officer standing on the driver's side of a vehicle may also be appreciable in some situations, they say. Rather than conversing while standing exposed to moving traffic, the officer prudently may prefer to ask the driver to step out of the car and off to the shoulder of the roadway, where the inquiry may be pursued with greater safety to both of them. So,
how many videos have we seen of an officer pulling someone out of the way just before they both get hit?
Yeah, it's constant, right? So they say not only is it dangerous for the traffic stops are dangerous, period.
Yep.
It's dangerous for the cop to leave them in the car because that person could launch an attack from inside the vehicle that the officer is not going to see. But in addition to that, that cop is standing out in traffic, essentially. And that can be super dangerous too. So it might be good for him and for the person that he has stopped, for them to order him out, move him on the side. So that is the overarching theme of the governmental intrusion argument. Mm-hmm. Next, they look into the argument about from the perspective of, hey, let's bolster personal liberty. So the personal liberty side of the argument. Against this important interest of the government, we are asked to weigh the intrusion into the driver's personal liberty, occasioned not by the initial stop of the vehicle, which was admittedly justified, but by the order to get out of the car. So again, narrow focus, right? We're not talking about the stop itself. So their liberty is already intruded upon. Mm-hmm. But so this government interest that's over here is weighed against the limited additional intrusion of actually asking them to get out of the car.
Not the stop itself.
Correct. The Supreme Court says, quote, we think this additional intrusion can only be described as de minimis.
Thanks for that again.
Yep.
A light. De
minimis is a Latin phrase meaning of minimal importance or trifling, used in law to describe matters too insignificant, small, or minor to warrant legal action or court attention.
Unlike his bulge.
Yes. And this one does not originate from Old English. It originates from Latin, which I'm going to try to say, and I'm going to do it wrong.
Yep.
But it often originating from the phrase de minimis non curat lax, which means the law does not concern itself with trifles.
Don't sweat the small stuff.
Don't sweat the small stuff. It helps.
But sweat the large bulges.
Yeah, by determining that things are de minimis, it helps courts avoid wasting resources in trivial disputes, right? And so they're saying this is de minimis. this is not a big deal. It is not an
Getting out of the
additional,
car is not a big deal.
not a big deal. They say, look,
I
the-
like minimally intrusive much better.
that makes far more sense. But again, it's not floral and
Mm.
poetic.
Floral.
The driver is being asked to expose very little more of his person than is already exposed during the traffic stop, right? The police have already lawfully decided that the driver shall be briefly detained. The only question is whether he's going to spend that period of time sitting in his car or standing next to it. So it's de minimis. It's small. It's inconsequential, says the United
Should have been a
States Supreme
rapper's
Court.
name, D Minimus.
That would be a cool name. Maybe that could be your rapper name. Stay tuned for
I
the
don't think
De
anyone
Minimis
wants that.
podcast. Not only is the insistence of the police on the latter choice not a, quote, serious intrusion upon the sanctity of a person, but it hardly rises to the level of, quote, a petty indignity. Again, quoting Terry for all of these reasons. What is at most a mere inconvenience cannot prevail when balanced against legitimate concerns for officers' safety. So they're
not even entertaining this.
No, not at all. They are straight up saying this is a minor intrusion. The police officer has a significant interest in safety during traffic stops, and that drastically outweighs the slight inconvenience of making you stand next to your car or get out of your car.
I'm just waiting for another comment that we've received before that just says the Supreme Court is wrong.
Yeah.
The end.
That was a good one. So that is very clearly settled by the Supreme Court. So what about the pat down, right? Because that's how we got here. We don't make case law by asking people to get out of their car and then they voluntarily
Giving
comply,
them a ticket
and then we give them a
back in.
ticket and put them away, right? That's not how case law is made. So in this case, this guy had a gun and was charged with 2 crimes for which he was convicted. So what about the pat down?
If he had had a better holster, he wouldn't have noticed.
Probably. That's true. Supreme Court says there remains the second question of the propriety of the search once the bulge in the jacket was observed. We have as little doubt on this point as on the first. And this
De minimis amount?
No.
Okay.
But they're saying we're as clear on this one as we were on the first one.
Yeah.
And that answer is controlled by
Terry
v. Ohio. Again, in that case, we thought the officer justified in conducting a limited search for weapons once he had reasonably concluded that the person whom he had legitimately stopped might be armed and presently dangerous. Under the standard enunciated in that case, which is whether the facts available to the officer at the moment of the seizure or search warrant a man of reasonable caution in the belief that the action taken was appropriate, there is little question that the officer in this case was justified. The bulge in the jacket permitted the officer to conclude that Mimms was armed and thus posed a serious and present danger to the safety of the officer in these circumstances. And any man of reasonable caution would have conducted the pat-down, which is kind of interesting.
Any man.
Yep. They say
a reasonable person.
Yep. They're saying, hey, in the context of a traffic stop, if you see a bulge in somebody's jacket, you're good to go under Terry to pat that person down for weapons. So again, just kind of summarizing both things. The order to get out of the car issued after Mimms was lawfully detained. That's kind of important, right?
Yeah.
Was reasonable and thus permissible under the Fourth Amendment. So the state's justification for such order that officer safety is both legitimate and weighty, and the intrusion into Mimms' personal liberty occasioned by the order being at most a mere inconvenience cannot prevail when balanced against legitimate concerns for the officer's safety. Under the standard announced in Terry v. Ohio, whether the facts available to the officer at the moment of seizure search warrant a man of reasonable caution in the belief that the action taken was appropriate, the officer was justified in making the search he did once the bulge in Mimms' jacket was observed. So they reversed and remanded. Now, the significance of this case, right? This is huge. Pennsylvania v. Mimms established what is now known as a Mimms order. It's a Mimms order is what it's called. And it provides police with the categorical authority to order drivers out of vehicles during legal stops without needing additional justification. Let me say that again. It provides police with the categorical authority to order drivers out of vehicles during legal stops without needing Additional justification. Period. So if a cop orders you as the driver to get out of the car, you have to get out of the car. Period. There's no debate. There's no question. We are not having court on the side of the road. It was already settled in 1977. It's called a Mimms order. And the Supreme Court says if a police officer tells you to get out of a car as the driver of that car, you are getting out of that car. Period.
One way or another, and please just do it willingly.
Yeah, but how many body cams have you watched?
Oh my God.
Right?
This is always the thing.
Yes. How many body cams have you watched? How many people have you had tell you that, dude?
Mhm.
I can't even count how many times that I've asked drivers to step out of vehicles and they say, I don't have to do that.
You're like, and then you're like, well, now I'm going to form a podcast, so you're all more fully informed.
Well, but I want people to understand their rights.
Are you
because
going to use this on the side of the road now?
I have.
You can pull out the
be like-
video. Watch this real quick.
Watch the first 37 minutes of this video, and I'll be back with you.
Would get us in trouble real fast.
But no, it's like I've had so many people tell me that, and I'm,
You say quickly Google Pennsylvania v. Mimms.
I kind of
In this day and age, you can now.
what I straight up say is like, look, the Supreme Court already settled this in a case called Pennsylvania v. Mimms. It's a lawful command for me to order you out of the vehicle. So I'm telling you right now, get out of the vehicle. But so many body cams of situations that go completely sideways and people get hurt start off by people saying that they have the right to sit in their car, and they do not. You do not have that right. You have to get out of the car as the driver of the vehicle when a police officer orders you to get out of the car, and they don't need additional justification to order you out of the car. Period. Can I hammer that home any harder?
It's so important, though.
It's so important.
And
man.
like, if you're gonna argue it in court.
100%.
Argue the legitimacy of the stop to begin with.
Correct.
The rest of it, don't get yourself hurt. Don't get someone else hurt.
Yes.
Over this point when it's so settled.
I mean, we're talking what, almost 50 years ago now.
And still,
it's still prevailing case law. So it's 50 years of people who said I don't have to get out of the car being wrong.
And I didn't even realize how little they even argued it, essentially.
Yeah.
They weren't like a balanced.
No.
What was the vote?
I don't know the specific vote. I know there were.
And what are we going to do then?
Well, I will tell you in just a second.
Okay.
I think
the correct answer is I don't know, but I will find out.
That is always the right answer. 3 judges dissented on the federal constitutional issue.
Interesting.
So it's a
For
6.
Something that's saying it's de minimis.
Yeah. It's still a 6-3 vote though.
Yeah.
And again, we have 50 years of case law that supports this, that just says get out of the car. Like, please just get out of the car. You do not have that right to remain in your vehicle. And so many body cam situations that go sideways start with exactly that. They don't need reasonable suspicion. They don't need probable cause. It's settled. It is super settled.
They don't need to articulate
They don't need to articulate anything to you. If they order you out of the vehicle, get out of the vehicle, please.
This is why we hammer home knowing your rights.
Yes.
And knowing when you don't have them.
Exactly. And so many people think that they know their rights, and they're often wrong. I said that in one of our previous podcasts. I don't remember which one, but when I said that, I was thinking Mimms in my mind, because so many people don't understand their rights, and it's very, very important for people to understand their rights and what they actually are. And this one's super settled.
So you don't get hurt.
Yes, and like, you don't need that, right? You don't need your window broken. You don't need, if you get pulled over for a traffic violation, right, and speeding, right, and officer tells you to get out of the car, and you get out of the car, you may still just leave with a speeding ticket, right?
Yeah, unless you got dead bodies in there, and then that'll probably be a problem.
Or you're carrying a snub nose 38 Saturday night special when you shouldn't be, but still, like,
you're still not going to get hurt.
No, and you're probably going to leave with just a ticket, right?
Yeah.
If you refuse this, you are imminently going to be arrested in a short amount of time. And what that arrest looks like is entirely dependent on your actions and how you react to that.
Get out and argue it in court.
100% argue it in court. You're going to lose that part because it's settled in 50 years of case law. But you can argue the initial reason for the stop.
The initial probable cause.
Exactly. That's why we have court, right?
Yep. And it's not to be had on the side of the road.
Yes. All right. I think I have properly beaten that horse to death.
Yes, you have.
It's just important to me. All right. So that makes abundantly clear about the driver of the vehicle. So what about the passengers of a vehicle? And interestingly, I actually thought this was interesting when I was prepping for this podcast. We go 20 years without that being answered by the Supreme
Even
Court.
though Mimms had a passenger.
Mm-hmm. Yep. So Mimms was 1977. We don't get to the next case until 1997, and that is the case of Maryland v. Wilson. So in this case, the Supreme Court considers whether the rule of Pennsylvania v. Mimms that a police officer may, as a matter of course, order the driver of a lawfully stopped car to exit his vehicle extends to passengers as well.
Because in theory they have no reason to be detained at that point.
That's the argument.
Yeah.
Right.
Because they didn't commit the offense.
That's
to
the
cause
argument.
The stop.
That's how it got all the way to the Supreme Court, right? And humorous.
It's shocking that took 20 years.
20 years, dude. I was surprised. So interestingly, the Supreme Court also starts with just a bold declaration right at the beginning. So they say, hey, we're considering whether or not Mimms applies to passengers. We hold that it does.
Wow.
Period. Like you could stop there.
And good night.
You could stop there. We're not going to because we got to get into the nuts and bolts of this case. But yeah,
I don't think I actually showed that last time.
But yeah, right out of the rip, they're like, yeah, we hold that it does. So this case involves the arrest of Jerry Lee Wilson.
Jerry Lee Wilson.
Jerry Lee.
Not Jerry Lee Lewis.
No, Jerry Lee Wilson. At about 7:30 p.m. on a June evening, Maryland State Trooper David Hughes
Always a state trooper.
observed a passenger car driving southbound on I-95 in Baltimore County at a speed of 64 miles per hour.
In
a 55-mile-an-hour zone.
All right.
9 your mind.
That's a trooper.
Yeah, you better believe that's a trooper. The posted speed limit was 55 miles per hour, and the car had no regular license tag. There was a torn piece of paper reading Enterprise Rent-A-Car dangling from its rear. So Hughes activated his lights and sirens, signaling the car to pull over, but it continued driving for another mile and a half until he finally pulled over. During the pursuit, Hughes noticed that there were 3 occupants in the car.
It's a lot of them. And
that the 2 passengers turned around to look at him several times and repeatedly ducked below sight level. And
that's
then
a clue.
Reappearing, right? So for a mile and a half of this pursuit, they're looking back at him. They're ducking out of sight. A furtive movement, you may call that.
And that's called I don't want to walk up to that car movement.
Yeah, I'm so excited to get into this next one because as Hughes approached the car on foot, the driver alighted.
Ooh, on his own.
And met him halfway. They used the same word again.
Oh, 20 years later.
Yeah, dude.
Justice.
I didn't plug that in myself. That was the United States Supreme Court. Rehnquist was who authored this one. The driver was trembling and appeared extremely nervous, but nonetheless, he produced a valid Connecticut driver's license. So Hughes instructed him to return to the car and retrieve the rental documents, and old Wilson complied. So during this encounter, I had this back and forth, Hughes noticed that the front seat passenger, who turned out to be old Jerry Lee Wilson, was sweating and also appeared extremely nervous.
What was the temperature that day?
I don't know. It was a June evening. So
it was probably warm.
It was probably warm, but evening, I don't know. So while the driver was sitting in the driver's seat looking for the rental paperwork, old Trooper Hughes ordered Wilson out of the car. Wilson gets out of the car. He alights, if you will.
And obliged him.
He alighted, obligatorily alighted.
Yeah.
Anyways, Wilson gets out of the car, and a quantity of crack cocaine falls to the ground.
A quantity.
Yes.
Whoops.
Yep. So
he had all that time and he didn't get rid of it.
No, it had to have been like sitting in his lap or sitting in between his legs or something. So when he gets out of the car, it falls to the ground.
Which is why the driver got out.
Yep. So Wilson was then arrested, and he was charged with possession of cocaine with intent to distribute.
A lot of it then.
It must have been, yes. So, trial court, before the trial, believe it or not, Wilson and his attorney filed a motion to suppress the evidence.
As they do.
Arguing that Hughes ordering him out of the car constituted an unreasonable seizure under the Fourth Amendment. The circuit court for Baltimore County, the trial court, agreed
Interesting.
and granted Wilson's motion to suppress.
Hmm.
So the state appealed up to the Court of Special Appeals for Maryland. Remember
We've
that?
already done this. Yeah.
we have. So on appeal, the Court of Special Appeals of
I made a
Maryland.
joke of it last time, and someone was not happy with me. So
Really?
we leave it alone this
Okay,
time.
we'll leave it alone. So on appeal, the Court of Special Appeals of Maryland affirmed, ruling that Pennsylvania v. Mimms does not apply to passengers.
Interesting.
So the state continues to appeal, and they appeal up to the Court of Appeals for Maryland. And the Court of Appeals for Maryland denied certiorari.
Said no, thank you.
Said no, thank you. So
We're busy with
with
the small things.
So they continue the appellate process, and it makes its way all the way to the United States Supreme Court, who grants.
Certiorari.
Yep. So they just hammer it home right out of the gate. So they've already said, right? If we go back up here, right out of the rip, they say, yeah, we hold that it does. Period. And
Up
then,
where for the listener?
up through my notes.
Okay, thank you.
Yes. So then we come to their next one. Their next sentence is, we granted certiorari and now reverse. Period. They're just so matter of fact of like, yeah. All right. So they say, look, in Mimms, we considered a traffic stop much like the one before us today. There, Mimms had been stopped for driving with an expired license plate. The officer asked him to get out. When he did so, notices a bulge in his jacket. It's a .38 caliber revolver, blah, blah, blah. They go in and they rehash everything through Mimms. So they say Wilson, in this case, urges, and the lower courts actually agreed with him, that this per se rule does not apply to Wilson because he was a passenger and not the driver. Maryland, the state of, in turn, argues that we have already implicitly decided this question by our statement in Michigan v. Long.
Oh.
See how this works? And in Michigan v. Long, they quote it saying, in Mimms, we held that police may order persons out of an automobile during a stop for a traffic violation. And
all persons.
That's how they quoted Michigan v. Long. So Justice Powell, in a case called Rackus v. Illinois, they quote him as saying, this court determined in Mimms that passengers in automobiles have no Fourth Amendment right not to be ordered from their vehicle once a proper stop is made. So the state of Maryland is like, you guys already did this.
Mm-hmm.
And here's two quotes saying you already did this. The Supreme Court says, well, actually, we agree with Wilson that neither one of those are a binding precedent. Just because that was the verbiage used in those specific cases, we haven't specifically addressed the question that Wilson is asking. So nice
your
try.
Research sucks.
Yeah, nice try, state of Maryland, but we haven't specifically answered this question yet.
Because the context matters.
It sure does. We must therefore now decide whether the rule of Mimms applies to passengers as well as drivers. And you're never going to believe how they break this up. They break it up into the governmental interest side and the personal liberty side. So on the public interest side of the balance, the same weighty interest in officer safety is present regardless of whether the occupant of the stopped car is the driver or passenger.
Yeah,
So remember all those things we said about Mimms? Doesn't matter. Same things apply to a driver and a passenger.
Yep.
And they go on again to say, regrettably, traffic stops may be dangerous encounters. So 20 years later,
still are.
Still dangerous. So at the time, they
Present
quote...
day still are.
Yep. At the time, they quote 1994 statistics. So with police officer line of duty death statistics, you never have them immediately, right? They take time to process by the FBI. So the numbers that they used in 1997 were 1994 numbers. And they say in 1994 alone, there were 5,762 officer assaults and 11 officers killed during traffic pursuits and stops. And that is straight from the FBI uniform crime reports. In the case of passengers, the danger of the officer standing in the path of oncoming traffic would not be present, except in the case that a passenger is in the left rear seat, obviously.
Yeah.
But the fact that there is more than one occupant of a vehicle increases the possible sources of harm to the officer. So they use traffic as a justification in Mimms, right? So they're like, okay, that only applies to this specific person. But now you're talking about multiple people in a car. So yeah, it's still super dangerous to the officers. So all the
More
things
dangerous than just one occupant.
exactly. So everything we said in Mimms is still applicable. Here's some numbers to feed on to justify why it's still applicable. So then they look on the personal liberty side of the balance. The case for the passengers is in one sense stronger than it was in Mimms for the driver,
That's agreed.
because there is probable cause to believe that the driver has committed a minor vehicular offense, but there is no such reason to stop or detain passengers. But, says the Supreme Court, as a practical, Wilson argues that because we have generally eschewed bright line rules in the Fourth Amendment context, referencing Ohio v. Robinette, guarantee we're going to do that one too.
Mm-hmm.
The Wilsons argues that the Supreme Court should not conclude that passengers may be constitutionally ordered out of all lawfully stopped vehicles. So the Wilson and his attorneys are like, look, you don't make bright line rules, so you shouldn't make a bright line rule here. And the Supreme Court goes, well, we typically avoid per se rules concerning searches and seizures.
Because the context matters.
Yeah. But that doesn't mean that we've always done that. In fact, Mimms itself drew a pretty darn bright line rule.
Yep,
And
sure did.
we believe that the principles that underlay that decision apply to passengers as well. So that's the third time they've straight up said
no.
So the statistics that they have and that they provide are not broken down as to assaults by passengers or assaults by drivers. And they say, look, it's regrettable that the empirical data on such a subject is sparse, but we can't ignore the data that does exist just because refinement would be better, right?
Mm-hmm.
So they're saying just because we don't know specifically how many come from drivers and how many come from passengers, yeah, that'd be great to know. Just because we don't happen to have those exact numbers doesn't mean we're going to completely ignore the fact that traffic stops are dangerous and anybody in a traffic stop can be dangerous.
And then they ordered the FBI to come up with that statistic.
Yeah. So this is awesome. You'll love this. They quote one of the dissenting justices and throw it right back in his face.
Interesting.
Yeah. So
is it the Chief Justice doing this?
Justice, yeah.
That would have to be.
Yeah, it's Rehnquist.
Yeah.
So Justice Stevens agrees that there is a strong public interest in minimizing the number of assaults on law enforcement officers. Well, we believe that our holding today is more likely to accomplish that results than if he got his wish, is pretty much what they say. So they again go in further into the justification. They're like, look, passengers are already stopped by the virtue of the stop of the vehicle.
Yeah.
The only change in the circumstances that would result from ordering them out of the car is that they'll be outside of rather than inside of the already stopped car. So outside of the car, the passengers will be denied access to any possible weapon that might be concealed in the interior of the passenger compartment.
Mm.
And it would seem that the possibility of a violent encounter stems not from the ordinary reaction of a motorist stop for a speeding violation, but from the fact that evidence of a more serious crime might be uncovered during the stop.
Like
right?
having tons of cocaine
Exactly.
on your lap.
And the motivation of a passenger to employ violence to prevent apprehension of such a crime is every bit as great as it is for the driver. So they're saying it's the same. And then they give an analogy example for us.
Ooh.
Yeah, they say that actually, back in 1981, so 16 years prior, we issued an opinion in Michigan v. Summers. The police had obtained a search warrant for contraband thought to be located in a residence, but when they arrived to execute the warrant, they found that Summers was coming down the front steps of the house. So the question in that case depended on upon a determination whether the officers had the authority to require him to re-enter the house and remain there while they conducted the search. So in the holding of that case, the court said, although no special danger to the police is suggested by the evidence in this record in that case, the execution of a warrant to search for narcotics is the kind of transaction that may give rise to sudden violence or frantic efforts to conceal or destroy evidence. The risk of harm to both the police officers and the occupants is minimized if the officers routinely exercise unquestioned command of the situation. So they're saying, in summary, look, that is what we said in Michigan v. Summers. The same logic applies here, right? That officers, the risk to both police and officers is minimized if the officers routinely exercise unquestioned command of the situation. In summary, danger to an officer from a traffic stop is likely to be greater when there are passengers in addition to the driver of the stopped car. While there is not the same basis for ordering the passengers out of the car as there is of ordering the driver out, the additional intrusion on the passenger is minimal.
Minimally intrusive.
Yep. We therefore hold that an officer making a traffic stop may order passengers to get out of the car pending completion of the stop. The judgment of the Court of Special Appeals of Maryland is reversed, and the case is remanded for proceedings not inconsistent with this opinion. So again, they
said all of you are wrong.
Yes, the Mimms rule applies to passengers as well as drivers, and they made it as clear as it could possibly be. So why is this significant, right? Again, it extends that Mimms order to everybody inside of a lawfully stopped vehicle. It solidified the legal standard that during a traffic stop, police officers have the authority to control the movements of both the driver and the passengers to ensure scene safety. So it's these two cases, Pennsylvania v. Mimms and Maryland v. Wilson, are intimately tied together. They say the same thing. They came to the exact same conclusion, that if a police officer orders anybody in a car, driver, passenger, does not matter, during a lawfully conducted traffic stop to exit that vehicle, they absolutely have to exit that vehicle.
Without any other justification.
No additional justification needed. That's all I need.
So
Because traffic stops are dangerous enough.
So if you're a passenger, just get out or argue it in court.
Yes. Yeah. Rewind back to when I got all fired up in Pennsylvania v. Mimms and just re-listen to that from the perspective of a passenger, because it's the exact same. The Supreme Court says it's the exact same. Maryland v. Wilson just said Mimms applies to passengers.
Yep.
And there's still statistics that say that traffic stops are super dangerous for officers. So latest that I could find, quick search, was 2024 numbers.
That's actually fairly recent.
It is fairly recent. Traffic-related incidents were a major cause of officer fatalities, with 46 traffic-related deaths, including 17 officers struck outside of their vehicles. Additionally, 39 officers were shot during traffic stops in 2024 alone. So those are just some quick numbers, and that's just cops getting hit by cars that are passing their traffic stop and cops getting shot by people in the midst of traffic stops. And so the same logic that the Supreme Court had in 1977 and had again in 1997 still applies in 2026. Traffic stops are dangerous to cops. They need to be in control of that situation. It's such a minimal thing, right? Remember, we're always talking about those scales of balance of government intrusion versus personal liberty.
Yep.
And the Supreme Court is abundantly clear that the governmental interest in officer safety drastically outweighs the de minimis, the inconsequential, the merely inconvenient intrusion upon personal liberty of asking somebody to get out of a car. So that's it, Dave. That is
to clear it up.
That is Mimms and Wilson.
Once they're getting out of the car, beyond that, the Supreme Court didn't say then what they could or could not do.
No, they did not. But they were clear again. At least I think it's pretty neat that they gave us the analogous decision from Michigan v. Summers, because the wording that they used, and they quote it specifically in Wilson, is that the risk of harm to both the police and the occupants is minimized if the officer routinely exercise unquestioned command of the situation. That, I think, really drives home what the intent of the Supreme Court is for the police's authority and command during a traffic stop. The police are in charge. The police have to stay in charge. And if in doing and lawfully executing their duties, they order you to get out of the car, they're well within their authority to do so. Again,
if they don't have control, everything goes wrong.
Correct. So again, and just so we're abundantly clear, because we talked about this in Pennsylvania v. Mimms, Maryland v. Wilson is still the precedential case law. Nothing has trumped that. It is still prevailing. Almost 20 years later, we have 20 years worth of case law where cops are allowed to order passengers out of vehicles, just like they are drivers. So that's it, man. That's all I got for you. Two super important cases, right?
Absolutely.
All cops know Mimms and Wilson. They should, right? Because they need to know that they have the authority.
They certainly should.
They need to know that they have the authority to ask people to step out of the car. But I don't think a whole lot of cops know the specifics of why. I don't think the cops know what exactly happened in this case and the various arguments that were made. And the context matters, as you always like to say. So that's all I
And how
got for
much
you,
the
buddy.
Supreme Court did not weight that other side.
Yeah. De minimis,
Yep.
which
All right.
they do not concern themselves with trifling affairs. So they
No,
were pretty
no,
clear
they
on it.
certainly do not.
So if
What's
you
not
are
a trifling affair, to
Ooh,
cut you off,
nice.
is hitting the like and subscribe button to the podcast so that we can reach more people like yourself,
You're getting
so that
pretty
they
good
can
at these
learn.
segues.
Yep, so they can learn their rights and not get into fights and arguments on the side of the road when they are abundantly incorrect,
And
as the Supreme Court has said.
yes, and one thing I wanna hammer home too for our listeners out there, because we don't have just cops listening to this podcast, and
No,
I
we
love that.
which we were not expecting.
We were not expecting. I was expecting it to be mostly cops, and it's not. And I love that. That really excites me. And I want to hammer home the point that we are not saying that this is an us versus them sort of thing. What I'm saying is, I want you to know your rights. I want you to be correct on your rights. And for these two cases, it's abundantly clear. So please, please, please know your rights is what I'm asking.
And send this to other people so they're more fully informed as well.
Oh,
That send it to your friends.
yes, send it to your friends.
They don't have to like us. That's fine.
No, that's okay.
We're just trying to teach you your rights.
Yes, we are trying to we want to make smarter cops because smarter cops make smarter decisions, right? That same logic applies to the private citizen. We want to make smarter private citizens because if you're a citizen stopped by the police and you're smarter, you're going to make better decisions, right? So if you have that pre-programmed knowledge ahead of time, because you can't, life has no pause button, right? You can't pause and
unlike your watch
and look up the answer. This doesn't have a pause button.
No, it certainly doesn't. What does it do?
This one tells time.
Okay.
Yeah. This one's got a helium escape valve, which I'm never going to use and nobody ever does ever.
Helium escape valve. That
yeah.
seems like something that's unnecessary.
We could talk about saturation diving if you'd like to.
I'm good.
But thank you for bringing that up. I was afraid you were going to forget.
I would never.
But smarter citizens make smarter decisions too, right? You can't put a pause on life and be like, hold on, Mr. Police Officer. Let me do some research on whether or not you can lawfully order me to exit my vehicle. So you need to know that ahead of time, right? Be correct about your rights, but know your rights. All right?
Yep. Drink more water. Hydration is important.
It is. So when it comes to physical fitness, last time we talked that consistency is 80% of that equation.
Mm-hmm.
Another 10% is progressive overload.
Meaning heavier weights.
Yes.
Or more activity.
One or the other, right? More stress. So progressive overload, right? There's two main camps in this, and that is one, it gets a little bit heavier over time, or two, you add reps, add sets over time. Either one of those things both accomplish progressive overload, and that is 10% of the equation, along with consistency, which is 80% of the equation.
And the next 10% will be on episode 9. It feels weird.
Episode 9. It does.
Thanks for sticking with us.
Yes. Seriously, guys, thank you so much for sticking with us. We really appreciate you. And we hope to see you in the next episode.
Share us with your friends. If we don't like it again, just do it again.
We'll just record until 1 a.m.
Oh, my phone can't handle it, apparently.
No, apparently not. We're 4 minutes in. Your phone might be loaded already.
I'm loaded.